Yes, Mr. O'Donoghue.
My Lords, just to wrap up on 1A and 1B, and then I'll very quickly deal with 1C and 4B. I said I would show the court the references in H3 to where the lack of clarity in the CMA's case is made good. So the first core bundle, tab 10A. There are a handful of references. It starts at paragraph 21.5, which is at page 316. And it's internal page 16. 374, electronic file. And it starts section G.
Sorry, page 16 of what?
H3.
374 electronic bundle, internal page 16.
Which paragraph of it?
And that'll 21.5 of H3. And it's the second part. However, precisely what case the CMA thought it was putting became a question of some complexity and difficulty when it came to the hearing of the due process question. I've showed you that on the transcript. Then 52 subparagraph 2.
Mm-hmm. So where are we now?
My Lord, it's internal page 43, still in H3.
Yeah.
So it starts how underlined. Then it's the middle of that subparagraph. The appellants were right in saying that CMA has not been particularly clear in the collateral understanding. It was alleging merely that there was a collateral understanding of some sort. Then 66, this point is triangulated with the fairness issue. If the CMA cannot explain what its defence of the decision was months after that case was put, chances of that case having been put properly in cross-examination during the course of the appeals are vanishingly small. Cross-examination is difficult enough when one knows what one is seeking to elicit. Cross-examination without focus is both unfair to the person being cross-examined and liable to end in failure to the cross-examiner themselves. And then two final references. Paragraph 71. In an attempt to understand the CMA's case on the defence of the decision, the tribunal sought, in the absence of any formulation by the CMA itself, to assist the CMA by framing the case for itself, and then you'll see the formulation. And the formulation is very, very important, because if you look at the quotations, AMCO promises to enter the market, even if able to do so. And that, not to enter the market, even if able to do so. That is exactly my point on the unilateral contractual right to enter in 3 months' notice. The CMA has to say, and has to put fairly and squarely, do not intend to exercise the contractual right because you have agreed the opposite. Finally then, 72. Last sentence. Although the CMA is quite prepared to critique someone else's formulation of the CMA's own case, the CMA remains unable to frame what its defence of the Hydrocortisone decision actually was. And in my submission...
Sorry, what was that last reference?
My Lord, it's paragraph 72, final sentence. Starts, as will be seen, although the CMA is quite prepared to critique someone else's case, formulation of its own case, CMA remains unable to frame what its defence of the decision actually was.
What does this tell us?
Well, it goes back to the point of the 26-page post-due process hearing CMA submission, which is when they were asked during the hearing and following the hearing what is your case on the distinction between the written stuff and the unwritten collateral agreement, they were unable to clarify that.
Well, it says that, but on the other hand, in H2, the paragraph 134, subparagraph 4 and 5, it pretty clearly said what the collateral understanding was and why it was illegal. So I find this absolutely extraordinary. I don't really understand how anybody allowed this to happen. It's bizarre. I mean, you all allowed this to happen. I don't mean that pejoratively, but did nobody say, what on earth is going on here? You've made all these findings in this judgment. This is really not something that should be happening.
Well, my Lord,
This should be going to the Court of Appeal if it's going anywhere.
well, what happened, of course, was that H2 was handed down in a closed circle. We were not given the option of H2 being unwritten. It said what it said.
No, but H2 said what it said, and then the unpicking of H2 begins apparently when you start the 2-day hearing,
Yes.
and it becomes apparent that the tribunal wishes to unpick the case that it had already found in favour of CMA,
Yes.
and nobody said, I think this is my Lord's point, nobody said, stop, this is not appropriate.
Well, my Lord,
You, I mean, without being rude about it, jumped on the bandwagon and said, oh, great, now we're having another argument about the CMA's case. And they, I imagine, sat in astonished wonderment.
well, what happened, of course, the CMA had a jurisdiction. They say you shouldn't be doing this. And of course, as is recorded in H3.
CMA had,
It's Funter's point, it's
The
jurisdiction.
Funter's
Yeah.
And we, of course, you'll see recorded in H3, a number of the applicants said, well, what should happen is H2 should stop before it enters into factual findings, then have a due process hearing. Having done that, then make the findings. So there was pushback.
right. And
So there was
where-
a suggestion, from the respondents, that the judge should, as it were, rewrite the tribunal should rewrite H2.
Yes.
Where did you
I think
say
it was
that?
Allergan submission.
Where did that get said? Can I see that?
Yes. It's in our Allergan submission. We said that the judgment should be retracted.
Judgment, what point did you say that?
Was that in your submissions before
Before
H3?
H3.
Yes.
It was, I was not actually, in fact, I did not argue, I was not present at the argument of H3, but I was aware of this as an argument.
And H3 records that.
And H3 was recorded.
And we understand there's only so far as counsel could go when you're in a moving situation. I mean,
Yeah.
you know, sometimes you can stand up and say, I need to put down a marker for the record, for the transcript.
Yes.
But there's only so far, only so much you can do.
Oh, Lord, yes, it wasn't being presented as facultative.
68.
Paragraph 68 of H3 records Allergan's submission.
Paragraph 68 of
H3.
Okay.
Sorry, wrong judgment. 68.
But Mr. Johnson did not press this approach in oral argument.
There's a point at which tact prevails.
Yeah.
And my lords, as I indicated, we are where we are.
Well,
And what certainly happened, rightly or wrongly, was that the 2-day hearing did transmogrify into something that was not actually primarily about due process. It was about a wide range of other things. And one of those things, which is very important for my submissions, is the lack of clarity on the distinction between the written stuff and the unwritten stuff. We see that in spades in H3. Now, just to round off my submissions on this, 3 short points. First of all, we do say that the failure to distinguish clearly between the not objected to written contracts and the objected to so-called 10 milligram agreement is a fundamental error of law on the CMA's part. It is not simply a due process point. One can look at this in one of two ways. First, it is axiomatic that a public authority in a quasi-criminal sphere has to articulate the charge sheet, for want of a better phrase, in a way that is clear and consistent and coherent. Even looking at this in terms of ordinary civil pleadings, a pleaded competition law case has to have a certain minimum acceptable level of specificity and clarity and coherence for it not to be demurrable. And we say, from that perspective, the CMA's decision fails. Now, that is not a due process point. It is something actually much more fundamental. Second, and in any event, we do say that things that should have been put as a consequence of this point were not put. Now, I've given you some examples. Let me just crystallize the core of this. We do say, loud and clear, that in circumstances where AMCO had a unilateral right to enter on 3 months' notice, it had to be put to the witness that they had agreed with Organ not to exercise that right. And I can just give you one reference to this. It's in the supplemental bundle, volume 7, tab 33. It's at page 2843. We can just quickly turn this up, it's quite important. And for my Lord, the Chancellor, it's in tab 31, 2850.
Let's look at that.
So this is the transcript of the due process hearing. Starts at 9:11. Do my lords have that? So it's day 2 due process hearing. It's internal page 109, my lord. And it starts at line 11. So the President says, I think, to Mr. Jones, well, it's one thing to be told if you enter the market in 3 months' notice, the consequence is that we will terminate your supply. That is simply putting the terms of what is agreed, what is obvious in the face of the agreements. What is not being put is that there is something going beyond this which is distorting the effect of the written agreements and saying, even if we can come to the market, we're never going to trigger 3 month notice period, enabling us to do so, so we're going to stay out. So that goes to my Lord Justice Green's. Well, was the point about the not exercising 3 month notice period, was that put? Now, what Mr. Jones says is interesting over the page at 1110. He's not saying, hang on, we put that. And you can see what he says. He's effectively saying, well, I didn't need to. Now, in my submission, given what the contract says, there is no dodging that point. If there is a collateral agreement that this very important right to enter has been sacrificed in an unlawful agreement with order, that has to be put in the plainest possible terms. One cannot duck that point. Now, I could go on. The same is true, of course, of the 2-year non-compete. The same is true of the entire agreement clause in the contract, and so on. If the contracts were not being observed because of side agreements, a whole range of things, frankly, needed to be put and were not put. And then finally, I do say that at least some of these points necessarily implied serious wrongdoing on the parts of the witnesses, and that needed to be put. Now again, just to give you one example, this is very important. It's in the unagreed bundle tab.
Can I just ask you why? So a fact is a fact. It then has a coloration, serious wrongdoing, naughty, shouldn't be done. What does that element go to in a cartel case or an object case? Why is it relevant to ask that?
It'll be easier when we see the
But
document.
just as a matter of basic principle, why is that at all relevant? Why does it need to be put?
Well, let's quickly look at the document. This is maybe the simplest way of dealing with it.
I'm going to want an answer in principle.
Yes, I'll come back to
That
that
needs to be-
once I've made my point of the document. So it's in the unagreed upon tab 59. So it's in volume 3. My lords, it's page 1947. So I think Mr. Breedy touched on this briefly yesterday. This is very important. So these are emails in June. Of course, this is following the famous email of the 15th of June 2014, and it's Baton to Sully. And you'll see in the middle of the page, from Mr. Sully to Mr. Baton, John, I'm nearly ready to go back to Auden on the draft agreement. So this is the second written agreement. 2 points. So there's an issue about the price. And then the second bullet. They're trying to be very cute rather than non-compete, and I suspect trying to tie up our ability to compete, to acquire other competing products, or to give 3 months' notice, and sell our own ASCA version, and so on. I really don't like this, nor do I trust them. So I'm going to propose, instead of the overly complicated wording, we use simple, clear English of what the non-compete should say. And then you essentially see there what is now clause 2.2. And then Baton responds at the top, I'm fine with it, Rob, and he effectively gives the green light. So what you have here is, there is hand-to-hand combat between the AMCO lawyers and the Auden external lawyers on the scope of the non-compete. And the one thing that AMCO is frankly paranoid about is Auden tying it up in a non-compete that would affect its unilateral right to enter. And they're fighting tooth and nail for this. And Mr. Baton is cheering Mr. Sully to the rafters, saying, yes, go ahead and secure this clause. Now, if the CMA is right, so look at the date, the 18th of June. This is around the same period as their 15th of June email, a week before the contract is signed. If the CMA is right, Mr. Baton is laughing through his hands at what is going on. Because the one thing he is sending Mr. Sully out to fight for is the very thing on their case that he has given up in some side agreement. And in my submission...
Not really.
No.
He says, I'm fine with it, Rob. He says, you do what you like.
Well, it has to be put to Mr. Sully and Mr. Baton.
He doesn't want to be tied down too rigorously by the contract because he wants freedom of action depending upon the
Well,
price.
this is one of literally dozens of emails. And there's a fundamental point. What on earth is going on here with them fighting tooth and nail for securing maximum rights to entry when on the CMA's case, that's the one thing they've sold the pass on to Auden. And that has to be put to Baton and indeed to Sully. There's two possibilities. Baton knew fine well this right would never be exercised, and he played Sully like a banjo. Now that needs to be put to Baton. There is no innocent possibility of Mr. Sully being sent on.
So what do they have to
of his
put?
own.
You're acting in a Machiavellian way because you've got an ulterior motive.
No.
What do you have to put?
You, Baton, have sent Sully out to fight for this maximum right to enter. You, Baton, only yesterday gave up the very thing you're sending him to fight for. And that, of course, appears in the written contract. And what that effectively says is, well...
But hang on, your heading is about serious wrongdoing.
Yes.
So
What on earth is going on in this negotiation if all this has been given away already?
But if one's, the cross-examination is a sort of moving target, if you like. I mean, Mr. Mitru cross-examined Mr. Baton, and I know you don't like it, any of you on the respondent side, but the fact is, rather begrudgingly, as I think my Lord Justice Green said earlier, Mr. Baton effectively conceded a number of things. In fact, he conceded what it was that he'd said. That I think it's either page 26 or page 28, and he accepts that the impression he was giving is that if they did the deal at £1 or £1.78, whatever it was, he would stay out of the market. So Miss Dimitri had got what she wanted out of Mr. Baton at that stage of the cross-examination. Why on earth would she need to go on and ask him about some internal email which demonstrated that he hadn't told Mr. Sully? She didn't need to do that. If it was all that important, somebody could have re-examined Mr. Baton and said, like you said earlier, that can't be right, can it? Look at this.
And critically,
Was he re-examined on this document?
Critically, she would not say you're lying. Because whether the tribunal picked it up, I mean, you all know that if you cross-examine, you get an answer. You're always told, as young advocates, bank it. You get it on the transcript, and you come back in closings and say, go to page such and such. That's a concession. Maybe dragged out of the witness reluctantly. Nonetheless, properly analysed, it's a concession. So you wouldn't dream of saying, Mr. Baton, you're a liar, because you've, without necessarily even realising, you've got him. So
Well, Lord, there are literally dozens of emails from this hard-fought negotiation where numerous people are running around trying to secure maximum flexibility to enter. And at the very same time, it can only be Mr. Baton, on their case, has given away the one thing that everyone in AMCO is fighting.
It's not something that needed to be put to Baton in cross-examination. If anything, it was a matter for re-examination. Alternatively, it's a matter for submissions. No doubt submissions were made. Strenuous submissions were made at trial on the basis of these emails to the effect that Mr. Baton hadn't conceded what the CMA alleged he conceded.
It is saying in its most fundamental sense that what is set out in the contract is not the real agreement. And there is no getting away from it.
Okay, look, I think we're going round in circles.
Yes.
I, for one, have noted your submission very carefully, Mr. O'Donoghue, but I'm still hoping that I will get a piece of paper with what you and Mr. Greeley say ought to have been put in absolutely clear terms.
Yes, Your Lordship. So just to wrap up on the other 2 points, which are very short.
Yeah.
Issue 2C. Can we quickly remind ourselves?
Issue 2C.
Sorry,
C, 1C.
It's 2C of the grounds of appeal. It's 1C of the list of issues.
Which is what?
Well, it's at the very start of the core bundle. So this is the other evidence. It's on page 4 of the core bundle. Did the CAT hold that the only evidential basis for the CMA's case on the 10 milligram agreement was the value transfer? And if so, was that an error?
What's your answer?
They didn't.
They didn't.
They did not.
They did not. So that the value transfer was not the only evidence, and they didn't say it was.
They never said it. And indeed, one can already see that in the paragraph that the CMA relies on, which is 1910 of H3.
in H2.
H3.
Will you need that reference again, Mr. O'Donoghue?
My Lord, it's paragraph 1910 of H3. And it's internal page 13.
Unpromisingly starts, the value transfer was the only basis for inferring the existence of the collateral understanding.
Well, yes, but this is recording the tribunal's findings, not the CMA's case. Because if you read on, it says, it mentions the ASIC case. You'll say, well, you lost on that, so that doesn't help you. And then if one goes forward to '64, one goes forward to 64.
Paris 60.
Paris 64. You see in the middle of that, the CMA had a further point concerning ASICA, which Miss Lifton killed. And then at 126, one two six of H3. They set out the CMA's written closings in substantial part, and then in paragraph 20 in the quotation, they list the CMA's case. So the suggestion, and then 127, the CMA, correctly stresses the fundamental importance of the collateral understanding. So the suggestion that there were bits of the CMA's case CAT simply forgot about is wrong. Now, it doesn't matter, given what I've said, but in their grounds of appeal, there's a whole shopping list of things the CMA says the CAT didn't deal with. Can I just quickly show you one document? It's paragraph 66 of our skeleton. It's in tab 6 of the core bundle. On page 197. So we go through each and every one of the things they allege the CAT somehow forgot about. We say, well, that is not so. And we give references. I mean, most of these points, frankly, are recycling exactly the same point in the value transfer. They're not independent points, but in any event, CAT, insofar as relevant, dealt with them. There's a very important point in 66 subparagraph 4. So one of the points in the shopping list is, oh, well, you forgot about Waymate, and that was sort of part of our case as well. But in paragraph 141 of H2, the CAT found that the Waymate agreements could not be weaponized against AMCO for the subsequent period. And there is no appeal by the CMA against that finding. So this shopping list in my submission is either completely misdirected, tilting at windmills, or trying to deny something which is plain on the face of these judgments. The only point the CMA therefore has left is a very narrow point concerning the summer of 2014, the suspension of the ASICA project. I just want to make 3 very quick points on that. First of all, we say this is a naked appeal on the facts, and therefore should not be brought forward in this court.
Sorry, it's what?
A naked appeal on the facts.
Negative.
Naked appeal on the facts.
Yes.
Which should not be brought forward. You have Mr. Brealey's point that the primary reason in H3 why the CAT doubted an agreement not to enter was the question of commercial rationality and incentives. And with respect, if that is correct, the question of ASICA is neither here nor there. If it was commercially rational to enter, and that was AMCO's intention, that's the end of it. Second, of course, what the CMA's challenge on this ASICA suspension point doesn't change is that for 2012, 2013, and 2014, up to and including the period of the second written agreement, there is no appeal CMA's case, which was killed by Miss Lifton, all of that period stands unchallenged. So the highest one can put the ASICA point on the suspension is that somewhere towards the middle of the infringement period, CMA has, it says, a bit of a point. For the early period, there is no challenge whatsoever to the ASICA evidence, which, frankly, blew up in the CMA's face at trial. Their case was a deliberate go slow. That case was demolished by Miss Lifton. She said the whole thing was embarrassing. And finally, the court, I think, has my point. In any event, even on this narrow suspension issue, I showed you the passages in cross-examination where what was put to Mr. Baton was the reason you suspended is because of the contract. That doesn't get the CMA anywhere. Now, just to give you two references before I move on to my final point. If we go to the transcript, it's at supplemental 7, page 592. So Mr. Bacon's cross-examination. Tab 7. So in my bundle, it's 592. In the old bundle, it's 589. That's at the bottom of the page, my lord. So this is Mr. Bacon's cross-examination. So he's been asked about suspension. He says at the bottom of the page, if we had just signed the agreement with Alden, then we would have needed to give them 3 months' notice to launch. So he's saying, yes, I quite agree. It's the contract. And then finally, on the decision itself, to go back to the core bundle, tab 11. My page 993. This is the decision. It's in the second core bundle. So it's paragraph 629, 0 and 291. 291, the CMA says, because of the second written agreement, AMCO paused its activities with ASICA. So they agree this is because of the contract. And then finally in 1271, at the back end of the decision, volume 3, 1271, paragraph 10. This is Mr. Brealey's point. There is no evidence that AMCO seriously considered scrapping the ASICA project, and so on. So it is not correct that the ASICA project was suspended. In fact, on the 2nd of November 2015, the product that AMCO ended up entering the market with was an ASICA product. So the suggestion the project was suspended is simply not true. And finally, very briefly on issue 4B, which is our appeal in relation to H2, two short points, if I may. I should be done in about 5 minutes. So this is our appeal against H2. And on the first point, can I quickly look at a paragraph of H2 just to anchor ourselves? What was found. So it's in volume 1 of the core bundle. (10B), page 482. And it's paragraph 144, subparagraph 5. This is the point about it being commercially imbecilic for Auden to offer the price that it did. And over the page, 145, subparagraph 8, there is essentially an inference from that there must have been some side agreement between Mr. Baton and Mr. Patel that AMCO would not just stay out of the market, but would take Auden's product and sell it at the prevailing market price. So the point being made here in H2 is essentially the only conceivable basis or explanation for what occurred is an inferred anti-competitive agreement. Now, Ms. Ford will deal with the
They
procedure.
don't mince their words, do they? It's not a marginal finding.
At this stage, my Lord, that's quite right, albeit provisional. Now, Ms. Ford will deal with...
Provisionally imbecilic.
Yes, well, in fact, there is an explanation that is not imbecilic, which is the point I'm going to come to. Now, Ms. Ford will deal with the procedural side of this. I'm going to deal with the substantive point. Now, we say in H2 there is an error because there is a non-infringing explanation for why Auden offered the supply price that it did. And moreover, that explanation was one the CMA has itself previously accepted as a good one which is non-infringing. So this is the original theory of harm we saw this morning in the first statement of objection. So just quickly to go back to that. This is the incentives theory. It's in the unagreed bundle, volume 3, 70. So this is the incentives theory. 4.105 and 4.109. So as your lordships may recall, the original theory of harm then jettisoned was that the contracts were themselves infringing because they gave rise to incentives offered by Auden for AMCO not to enter the market with its own product. And as we saw in 2.27c of the decision, that theory of harm is, and I quote, no longer part of the CMA's object case. It has been dropped. So the CMA accepted, ultimately, that it would not be an object infringement for Auden to seek to incentivize AMCO not to enter the market with this low supply price. And indeed, we see in H3, in contradiction to H2, the tribunal essentially accepting that sort of point. So it's in paragraph 83 of H3. 83.1, they say, uncommunicated common understanding does not, in our judgment, represent a competition law infringement. Contrary might be arguable, but has never been argued by the CMA. The position was not one that was open to CMA to take. That position had been taken by the CMA in its first statement of objections, namely the first written agreements were in and of themselves infringing competition law, and had been abandoned by the CMA towards the end of its investigation. It was not subsequently open to the CMA.
So which paragraph are you reading?
My lord, it's 83.3 of H3.
Oh, sorry, yeah.
Page 416.
Okay, sorry.
So in my submission, what we see in H3 and 83 is the tribunal saying, well, there is a non-infringing unilateral conduct explanation for what Auden did, which is it was trying to incentivize AMCO not to enter. That is not a Chapter 1 agreement. One of the curiosities is that when one then looks at H2, that explanation isn't even mentioned. And in circumstances where the regulator itself had previously found, albeit provisionally, that Auden was willing to offer those terms unilaterally, the CAT's failure in H2 to consider this explanation, we say, is an error of law. And indeed, one could go further. One might even say that no reasonable tribunal could conclude, as the CAT did in H2, that it was commercially imbecilic of Auden to do so, certainly without further evidence. And this applies a fortiori, where in H3, in 83.2, they accept the force of this. And indeed, once one accepts that there is a credible, non-infringing unilateral conduct explanation for Auden offering the supply terms it did, without a collateral agreement on the part of AMCO, the analysis in H2 collapses entirely. Obviously, in those circumstances, it has been in AMCO's interests to accept those terms without more. Not to do so would be a stark case of looking a gift horse in the mouth.
Is this a point of law or just an objection to the fact finding?
Well, it is a point of law.
What is it?
That the regulator has previously accepted, or has now accepted, that merely offering an incentive by way of a low price to incentivize AMCO not to enter the market, that uncommunicated understanding, that would not be a Chapter 1 agreement, it is unilateral conduct.
But what's the point of law in the paragraph that you've identified in the CAT judgment where they've gone wrong in law?
Well, in H3 they
Is
say...
it the finding that it's imbecilic?
Well, yes, because the explanation, or an explanation for the low price, was not an infringing or inferred Chapter 1 agreement. It was unilateral conduct by Auden to incentivize AMCO not to enter the market.
But you're just disagreeing with the fact finding. I mean, as you know, we have to be ever so careful about our jurisdiction. We cannot entertain an objection to the facts unless it is properly classified as a point of law. And factual matters can be in some circumstances. And at the moment I'm struggling. What's the point of law in your objection to this fact finding?
In H3, they accepted as a matter of law that there is a non-infringing, a non-Chapter 1 infringing explanation for the low price, which is incentivization, not considering that same explanation in H2 as being a rationale for the supply price, and therefore for an absence of a Chapter 1 agreement. That is an error of law. In H3, they've identified in law a complete non-infringing Chapter 1 explanation for the low price. H2 doesn't even
So one or
mention.
other of those must be wrong.
Yes. Well, it goes deeper than that, because of course, having jettisoned the SO theory of harm,
Because there was no part of the decision. I mean, that was, I don't know what status one attaches to that, those 1.5 lines in H3, but
well, it is part of the decision, because 227C says they no longer pursue the incentivization theory of harm. And the error of law in a nutshell, my lord, is the failure of the tribunal in H2 to consider the sufficient explanation in H3 was a complete answer to the question of the rationale for the supply price.
I'm looking at the structure of the logic in subparagraph 5. Auden's position was odd. Well, the tribunal conclude that it's more than odd. It's incomprehensible, imbecilic. And they then infer from that that something else had to come. There had to be something else. Otherwise, it is imbecilic. Isn't that an inference to be drawn from a fact?
Well, my lord, yes, but then when one looks at 83.2 of H3, they're saying, well, there is, in terms of unilateral conduct, a perfectly obvious explanation, which was the CMA's own theory of harm, the SO, for why this low price was offered. The rationale was they're trying to incentivize AMCO not to enter. That is not a Chapter 1 infringement. And my point is the failure to consider that point in H2 is an error of law. In other words, in H3, they gave an explanation of what they regard as commercially imbecilic and inexplicable in H2. So it's the inconsistency.
It's an illogical inconsistency
that I rely on.
2 paragraphs of
And of course,
connected judgments.
Indeed. And again, it is not the CAT in a frolic of its own. It is relying on the regulator's own decision to jettison the incentives case as providing the ballast for that. So we say as a result of say fortiori. My lords, we had some detailed points on, which are set out in detail in our skeleton on why H2 essentially, and I choose my words carefully, why H2 essentially does not grapple in any meaningful way with the enormous volume of contemporaneous evidence that Mr. Brealey's client and my client had put forward. And what one regrettably does not see in H2 is an event-by-event analysis of the contemporaneous documents, setting out where the battle lines were drawn. Your Lordship's in a very invidious position where Mr. Turner has his 7 greatest hits documents. Mr. Brealey has other documents that he presents from the cherries he's picked. And for this court, in the context of
same side or different side?
well, I'm trying to be reasonable. In the context of a 41,000 document case, for the CMA to turn up and say, well, here's 7 documents, we win. Mr. Brealey say, well, hang on a second, I've got 27. Your Lordships, realistically, in this forum, cannot be expected to grapple with that. And in my submission, with some regret, if H3 is upheld, then the decision does not stand. If we're into the realms of trying to understand, is H2 right in substance, we have a fundamental point, which is that, Mr. Brealey, that whole swathes of our case on the contemporaneous documents are not grappled with. And I'm afraid.
I see the sword of Damocles above my head.
Can I just ask you this? If we're against you on H3, and we were to decide H3 had to go, none of this should have happened, so the judgment on H2 should stand, then the points you make about what documents were or were not put are classic attacks on findings of fact, or saying the findings of fact were insufficient or whatever.
Well,
which is,
your Lordship's right.
Set itself against that approach, a fortiori in appeals from the Competition Appeal Tribunal.
Yes, well, your Lordship's quite right. That's what Mr. Turner says, but of course at the same time as him showing you his 7 documents. Now, in my submission, we're not in the realms of what about this bit of evidence and that bit of evidence. We say there is a category failure in H2 to grapple with contemporaneous documents. And that is an error. But again, I can't possibly get into the weeds on that.
Well, you've covered that in your written submission.
It's in.
Yeah.
And what we've done in our skeleton, and Mr. Brealey as well, is we've set out in condensed form. Here is the contemporaneous document counter-narrative that we put forward. And the failing in H2 is that there is no attempt to grapple in a sequential and event by event or document by document way with the argument and the counter argument on the document. It is a narrative which is conducted at a much higher level of abstraction. We say it, in a sense, has been a forensic or judicial failure to grapple with the evidence in sequential and traditional fashion. That's why we say it's an error of law. I'm not touching around the fringes of, well, we're at this point, we're at that point. It is a contrary. So, my lords, those are my submissions.
Thank you. Ms. Ford.
I'm dealing with 3 issues on the list of issues. The first is issue 1D, which concerns whether the CMA adequately put a case that AMCO had agreed not to enter the market with its own product. Then issue 4A, which concerns whether the tribunal's findings in respect of an agreement that it made in Hydrocortisone 2 exceeded the permissible scope of an appeal on the merits. And then issue 6, which concerns whether the tribunal went wrong in finding that any such agreement continued after the departure of Mr. Patel, who was the human actor who would have possessed any common understanding on the part of order. And the common thread which runs through each of the 3 points that I'm dealing with is this notion of an agreement or a common understanding and what is required to establish it. The content of the common understanding that the CMA found is, as my Lord Justice Flo has been saying this morning, what is set out in 6.17 of the decision. Elsewhere in this decision, we see the concept of the common understanding being referred as a commitment not to enter. So, for example, decision paragraph 6.355 says the key factor is whether in return for the payment the potential entrant gave a commitment not to enter the market. And the CMA also finds that the meeting of minds with the common understanding has to be ongoing. So paragraph 7.7 of the decision, it says that the anti-competitive agreements could only last for as long as the common understanding existed between the relevant parties. So what it must prove is an ongoing meeting of minds. What does the CMA have to show in order to make good that case? What the authorities tell us is that there needs to be a concurrence of wills or a meeting of minds which goes beyond unilateral conduct. Can I ask the court to turn up, please, the ICI and Commission case, which is an authorities bundle tab 69 at page 2751. This is a case in which the Court of Justice is trying to articulate the distinction between parallel conduct between competitors, which is permissible under Article 101, and a concerted practice between competitors, which is impermissible under Article 101.
You may have to give me the page again.
The page is 2751, and I'm focusing on paragraph 118 in the judgment.
118, isn't it?
118, yes. What the Court of Justice says is that although every producer is free to change his prices, taking into account, in so doing, the present or foreseeable conduct of his competitors, nevertheless it is contrary to the rules on competition contained in the treaty for a producer to cooperate with his competitors in any way whatsoever in order to determine a coordinated course of action relating to a price increase and to ensure its success by prior elimination of all uncertainty as to each other's conduct regarding the essential elements of that action, such as the amount, subject matter, date and place of the increases. What, in my submission, the Court of Justice is doing here is telling us what is not enough to contravene Article 101. And what it says is that it's not enough to conduct yourself on the market in a particular way in anticipation of how your competitors might respond to you. What is required is a coordinated course of action whereby uncertainty as the way your competitors respond has been eliminated in advance. And the court will appreciate the relevance of this point because if, for example, AMCO were to threaten to enter the market with its own product in the hope that that might persuade Auden to offer it more favourable supply terms, then that is not enough because that is a unilateral anticipation of what its competitor might do, not an agreement. And similarly, if Auden, for its part, were to offer AMCO attractive supply terms in the hope that that might have the effect of making independent entry less commercially attractive, again in our submission that is not enough, because it is a unilateral strategy on the part of Auden. It is not an agreement.
It's an incentivisation point, isn't it?
My lord, that is, and that
If
is
it doesn't-
unilateral
if
conduct.
If there's nothing that crosses the line,
Your lordship has exactly the point, yes.
But there's quite a lot which has occurred since 1973, wood pulp, fire, which does, this was quite an old case and quite a naked explanation of what an agreement was or wasn't. And here we have a formal agreement and discussions over price and quantity. So it's not quite as, that's a very extreme position, which is modified slightly in case law.
My lord, I don't dispute that the case law has moved on to some degree, but in my submission, the key distinction between unilateral conduct on the one hand and either a concurrence of wills or a meeting of minds on the other, one of those two was the formulation.
In principle, there is a black line between something which is genuinely unilateral, and the question is what's meant by genuinely unilateral.
My lord, yes, and that is the factual inquiry that one must engage in.
Yeah.
Just to give a couple more examples which focus on the circumstance of this case, if the practical consequence for AMCO of obtaining supply from one source is that it doesn't need to obtain supply from another source, that is a circumstance which is itself entirely unilateral. It is not an agreement. And one of the ways in which Mr. Turner put the CMA's case on a number of occasions was that the supply agreement was the preferred alternative to market entry, or a more attractive alternative than the risks of competition. And in our submission, having that preference and even acting on that preference is not enough, because that preference is unilateral. It does not amount to an agreement not to compete. Now, just before we leave this paragraph, your lordships will see that what the Court of Justice also refers to is the elimination of uncertainty. And it's not talking about just any course of action which happens to minimise risk or commercial uncertainty for the undertaking concerned. It has to be removal of uncertainty about how your competitor might respond to your conduct. And so, for example, again, if AMCO decides that it would prefer not to run the risk that its own product might be unattractive to customers because it's skinny label, that unilateral decision that it doesn't want to run that risk is a legitimate one. It is not an agreement. And if Auden decides that it's prepared to supply AMCO because it does perceive AMCO's skinny label product as a potential risk, that again is a unilateral decision to choose to act so as to avoid that risk. And it doesn't satisfy the requisite test for an agreement. None of those in our submission discloses an unlawful agreement. So what the CMA has to show is a subjective mental element. It has to show a concurrence of wills or a meeting of minds that goes beyond unilateral conduct. Mr. Turner on day one cited some additional authorities, and those in our submission go to two slightly different points, and it's important to be quite clear distinguishing between them. The first is concerned with the form that any common understanding might take. And so, for example, it need not have the formality of a commercial contract, the coordination can be tacit rather than express, all that might be required is a nod and a wink. And we don't dissent from that at all. But the fact that the law isn't prescriptive about the form that the understanding might take doesn't detract from the need to show that that core mental element of the meeting of minds is actually present. And the second group of cases is concerned with the way in which one might go about proving the existence of a common understanding. And so, for example, it can be inferred from coincidences or indicia, and he cited the Superboc case. And again, we don't take issue with that as a proposition of law, but the way in which one might go about seeking to prove that there was this common understanding doesn't, again, in any way dilute the need to show, by some means or other, that there was this meeting of minds. And of course, insofar as the CMA is advancing a case that the existence of a common understanding can be inferred from evidence, from indicia, what one would expect to see is that the evidence in question and the inference that is said to be drawn from that evidence would be squarely put to the witnesses. I note in passing that what the CMA hasn't said, either in its grounds or orally, is that the tribunal has somehow made an error of law in its appreciation about what constitutes an agreement or a common understanding in the context of the authorities. It hasn't suggested that the tribunal has misapprehended what suffices to show an agreement. Finally, there's a question about how one shows that the subjective meeting of minds when undertakings are concerned are corporate entities, when the undertakings are concerned are corporate entities. And for that we look at Tesco and OFT, which is in the authorities bundle, tab 34, starting at page 1303. I'm looking at paragraph 62 of this judgment, and in particular the second half. This is a CAT judgment. And it says, since an undertaking comprising a body corporate can only act through the individuals employed by it, the acts or conduct of an undertaking are inevitably performed by those individuals. It follows that any act by any employee could potentially lead to an infringement attributable to their corporate employer with whom they comprise the same undertaking. So in this case, the common understanding must be present in the mind of individuals. And that may seem to be an obvious point, but I emphasise it because it comes up in relation to issue 6, which is how can any common understanding persist when the individual that may have had it has left. And just to be clear, this is a slightly different point than the point my Lord Justice Green canvassed on Wednesday about whether in the context of an object infringement one has a subjective anti-competitive intention and how one imputes that to an undertaking under sort of rules of corporate attribution. This is concerned with a more basic question about whether or not there's been a meeting of minds such as to give rise to an infringement.
Because of the passage of time and someone leaving.
That's issue 6, which I'm going to come to.
Oh, okay.
But each of the 3 issues I'm dealing with deal with this core question: have you shown that meeting of minds?
Yeah.
So, turning to how did the tribunal approach the question of a common understanding, and starting, please, with Hydrocortisone 2, we look at, starting at paragraph 7, subparagraph 8, which is internal page 10. And what the tribunal has done here is to record the content of the common understanding that the CMA found as set out at 6.17 of the decision, which is the one that Lord Justice Flo has been
Sorry, which one's that one?
This is subparagraph, paragraph 7, subparagraph 8 on internal page 10.
Yeah,
CMA,
okay.
the CAT's referring to how the CMA defined the content of the common understanding. We then look at paragraph, paragraph 10 within this judgment. What we see is the CAT rightly recording the sorts of points about form and proof that the CMA have emphasised, so that it doesn't need to be a contractual agreement or an express understanding. And if we look down to footnote 20, we see an agreement may be written or spoken or inferred from the circumstances. So it's got well in mind these sorts of points. Paragraph 11, Mr. Turner made the submission that the tribunal was in this paragraph mistakenly proceeding on the basis that the parties were concealing the nature of their agreement. In my submission, what the court's doing here is, what the tribunal's doing here is slightly different. What it's doing is it's contrasting a classic pay for delay case where the offending terms are clear on the face of the agreement, and one simply debates whether or not those terms are or are not an infringement. And that's the sort of examples it's giving in subparagraph 1 of paragraph 10, sort of classic terms on the face of the agreement issue. It's contrasting that with a case such as this, where there is a prior dispute about what the terms of the agreement actually are. And so one gets into a debate about what the agreement is, even before one gets to the next question about whether those terms amount to an infringement. And in that context, the tribunal is saying it's necessary to engage in a careful fact-finding exercise to ascertain exactly what was agreed.
Do you agree with the proposition at footnote 20?
My Lord, yes, we don't take issue with that at all. Those are the points that the CMA has made about form and about the way in which one goes about proving. And of course, the learned author of the document in question is in court.
Really? Continuing course of business? Moral obligation?
And so you,
Morally binding commitment.
it's not confined to legally binding contracts, but covers any morally binding commitment. It's sufficient if the undertakings have expressed their joint intention to conduct themselves in a market in a particular way. That's the wording, I believe, from Bayer. We don't take issue with the proposition that one doesn't have to have this formal piece of paper with the terms written on it. What we do say is that one mustn't let questions of form and evidence obscure the inquiry as to whether there really has been demonstrated to be the requisite meeting of minds between the persons concerned.
I mean, what I don't understand at the moment is if Mr. X and Mr. Y agree that they will enter into an uncompetitive, anti-competitive arrangement in breach of a Chapter 1 prohibition, and Mr. X leaves the company, but the company A and company B continue to deal on exactly the same terms without changing anything about the way they deal, how the anti-competitive understanding disappears when Mr. A or Mr. X, I'm sorry, I may have given the wrong names, leaves. I just don't see why that should be the case.
My Lord, the answer is, it depends whether the existence of the anti-competitive agreement that your Lordship's assuming depends on a common understanding which has arisen and which is continuing.
Yes.
That is
Continuing course of business dealings between the parties.
a continuing common understanding, what the CMA refers to in 7.7. There's an inquiry, is there this continuing meeting of minds? Now, if there is, if you're satisfied that there has been an infringement and that infringement is continuing, then the fact that the party that concluded that agreement, the individual that concluded that agreement, has gone is immaterial, because we are then simply talking about whether the undertaking itself has distanced itself from the offending conduct. But the inquiry in this case is a prior one, and it's whether there is an infringement at all and whether it can carry on.
Yeah, I get that, but I thought you were coming on to the second one, which is why I highlight continuing course of business dealings.
I know, but we can certainly come back to that in the issue 6 point. And the CAP grapples with whether the case law gives you a way through, and in our submission it's made a wrong turn on that, but we can come back to that one. Mind on looking at how the CAP was working through it, if we look at 15.1, instead of page 17, we see the tribunal rightly recording that unilateral conduct doesn't constitute an infringement of the prohibition, and this is the paragraph that you've already been shown about communications crossing the line. And similarly, if we go over the page, paragraph 2 is making the same point. Some arrangement must be shown, crossing the line must be shown, unilateral conduct will not suffice. So that is, in my submission, absolutely correctly identifying the issue in this case. We turn, please, to 92.
Does the concept of crossing the line add anything to the European case law? Or is it just a handle to describe it?
In my submission, it's not seeking to put a gloss on it. It's the way in which the tribunal has sought to articulate the need to have something beyond unilateral conduct. And and it has there drawn on domestic law, but it's saying the same thing. Picking up as we pass paragraph 92 in this judgment, and the reason I pick it up is because my Lord Justice Flo put to Mr. O'Donoghue the proposition that the CAT's essentially decided all of this in the course of its judgment. What the CAT explains in 92 and 93 is that the various findings which follow are dealing with the question of the purely unilateral state of mind of the undertakings concerned.
Sorry,
So
paragraphs.
It's starting paragraph 92, internal page 59. And the CAT's reminding itself, we appreciate that a common unshared intention is insufficient to satisfy the requirements necessary to establish the cartel infringements.
Yeah.
But the reason why it's going on to look at all this is because it thinks that individual states of mind as a means of informing what common intention might have existed. That's why it thinks that it's relevant. And it stresses again at 93, we stress that there can be no infringement of the Chapter 1 prohibition without something crossing the line, but in order to understand what crossed the line, the state of an actor's uncommunicated state of mind will be of considerable inferential assistance. The findings it then proceeds to make are as to the internal, uncommunicated, unilateral state of mind. And I'm going to show you that when it comes on to make a finding about the key question, the question of whether anything crossed the line, it resolves that question in a very different way than the case that the CMA puts. But I emphasise this paragraph because it's important to appreciate that all these findings do not provide an answer to this key question of whether or not there's a communication that crossed the line. Paragraphs 99 and 100 are again examples of the tribunal emphasising this point that one needs communication crossing the line. And again at 101, it's very clear the tribunal had these points well in mind. And it's worth emphasising that because there's obviously this concern that there was a material shift in focus in Hydrocortisone 3. But insofar as Hydrocortisone 3 is expressing a concern that the case about the common understanding, the case about the collateral side agreement wasn't put, the roots of that, the origins of that, the test that the tribunal is applying when it's looking at this material, they all do appear in Hydrocortisone 2. It doesn't appear out of the blue in Hydrocortisone 3. It's already thinking about what do I need to see in order to find this common understanding. It's already there in Hydrocortisone 2. On the particular facts of this case, the way in which the tribunal considered it was necessary to overcome the need to show a communication crossing the line was to infer an express conversation taking place between Mr. Patel of Alden and Mr. Baton of Amco. And that's the finding it makes in paragraph, starting at paragraph 143. We'll see the heading state of mind in regard to the second written agreement. And the tribunal makes the finding of fact that the terms set out in the second written agreement focused on what Auden would provide to Amco and omitted what Amco agreed with Auden, which it finds was to stay out of the market for as long as Auden's monopoly position could be maintained. And then at paragraph 144 it says we've reached this conclusion for the following reasons. And it sets out reasoning which culminates in subparagraph 8 on internal page 88. And this is where it says, we infer that there was a conversation between Mr. Amit Patel and Mr. Baton at which an agreement was reached, not only that Amco would stay out of the market, but also that Amco would take Auden's product and sell it around the prevailing market price as set by Auden. And this is the basis on which the tribunal then concludes at paragraph 145, we therefore affirm the conclusion reached in the Hydrocortisone decision, including in particular as to Amco's state of mind. The basis on which it does it is the inference that it's drawn in the previous subparagraph 8.
I mean, that's a strange thing to do when that's not CMA's case.
My lord, yes, and that is going to be the subject matter of my second point, my point that, I forget what number it is on the list of issues. But our submission will be that that exceeds the scope of what was open to the tribunal on a merits appeal. I'm grateful. It's issue 4A. What the tribunal then does is it's having reached a view
I mean,
about
did it preface that by asking anybody what they thought about it in submissions?
No. What it has done is it's reached a view, having heard the evidence and seen the documents, as to what it thinks is necessary in order to make out the case that the CMA was seeking to make out. It has taken the view that the CMA's case was insufficient.
Well, I mean, it's one of a million things that could have happened, isn't it? I mean, you can have a conversation over lunch. We know they had lunch together and didn't make any notes on a particular occasion. But as I say, it's one of a million things. It could have taken place in a phone call. They could have gone, could have had emails, texts, WhatsApp messages, maybe. I'm not sure about when we're talking. They could have, could have done a million things. I mean, but if none of this was put and wasn't the case, I don't see where it comes from all of a sudden at paragraph 144.8.
My lord, indeed, and the subject matter of what we say is a respondent's notice point, is that insofar as this is the basis on which the tribunal...
Well, it's very strange, and then they say we uphold the CMA, which the CMA doesn't say. There was a conversation in which this was agreed.
My lord, yes. And so they are upholding the CMA's finding of infringement on the basis that simply in our submission wasn't open to it. And I'm going to come on to the law.
And then they say dishonesty wasn't put, but they don't say, and the conversation we've just found happened wasn't put.
Well, it certainly wasn't. Obviously, the CMA's positive case is that it wasn't put. They say what they put was enough, and we're going to come on to
I mean, this
debate.
This gives a real conundrum for this court.
My lord, it does. And our submission is that this goes beyond the scope of appeal on the merits, and so the tribunal's overstepped what it's entitled to do on appeal.
So what?
And so the appeals must be allowed.
Well, if the appeal's allowed, then what? Retrial.
In our submission, if the tribunal has only felt able to uphold the CMA's case, having heard the witnesses and the evidence and seen the documents, on a basis which was not open to it because it wasn't put by the CMA, then the consequence must be that it upholds the appellant's appeals against the cartel infringement.
You win. Boom.
Yes.
Excellent. Great. Okay. It's easy.
I won't sit down quite yet.
No. Nearly Friday evening.
So this is the way in which the tribunal answered this crucial question about was there a communication crossing the line in the context of the second written agreement. And what it then does is it reasons back from what it has found about the second written agreement to answer what was the position earlier. And we can see that starting at paragraph 146, heading consequential matters from this conclusion.
Sorry, where are you?
I'm sorry, I'm back in H2.
146?
146, yes.
Yeah.
And they say, reasoning from this conclusion as regards the second written agreement. There are two further areas that we need to consider in order to make our findings complete and clear. And the first one, under the heading little Roman 1, the nature of the oral 10 milligram agreement and the first written agreement. And they say at 147, our conclusion is that the second written agreement was a more aggressive manifestation of what had gone before. We are not in a position to say with any precision how the oral agreement between Auden and Waymaid was concluded, but we are in no doubt that the substance of that agreement was as it was in the case of the second written agreement. And we see at subparagraph 2 under that, Waymaid and Co were agreeing to stay out of the market with their own supply and instead used a discounted supply from Auden and not to use Auden's supply to undercut Auden. And they go on to say, we consider these two aspects to be fundamentally linked and the second to be implicit in the first. It would not be in Waymaid or Amco's interest to price low, and Auden would expect any discounted supply made by them to Waymaid or Amco not to be used to undercut Auden's own price, and so to bring about the competitive outcome that Auden, Waymaid and Amco were striving to avoid. And they say, in short, it would have been important to Warden to maintain a high price across the market, we consider that such a common understanding would have been an inevitable part of the arrangement, so obvious that it would not require express statements. So this is a conclusion which has been drawn from what the tribunal has found happened in the second written agreement, reasoning back to the prior agreement, and then if the court looks at 149, they say there again our conclusions align with those in the Hydrocortisone decision. Align with, in my submission, is quite carefully chosen wording, because the tribunal is not expressly endorsing the findings of fact in the Hydrocortisone decision, because of course these findings of facts didn't appear. What it's doing is reaching its own different findings of fact, and it says that's led us to the same overall conclusion.
It's allowed to do that, is it?
Our submission will be no, it's not, and that again is going to, I'm going to come to that in the context of our respondent's notice.
I mean, okay, you say it's pretty glaring and it's not allowed to do that, but it would be open to the tribunal to find slightly different facts from those found by the CMA, reaching the same conclusion that there was anti-competitive conduct.
My Lord, yes, and I'm going to come on to show the court the authorities that exist on the extent of the flexibility that the tribunal's got to do that sort of thing. But our submission will be that this very much oversteps the line.
Well, and it oversteps the line there because of your putting point. Because it's unfair to make a finding that is not, obviously not put, and could have, you know, I mean, although one answer to that is, well, obviously the bloke said 100 times he didn't make any agreement. If it's found he did make an agreement and you put it to him that he made an agreement, he'll say no, won't he? He's got two choices. He either says, I agree, I did, or he says, no, I didn't. Of course I didn't, I've said so 100 times. But so the putting point is a bit weaker in this rather binary situation. But you say it's unfair to, because it could have been one of 100 findings. It could have been, oh, they had WhatsApp messages which we've never been shown. You know, and that's just made up.
My Lord, yes, to be fair, the tribunal isn't prescriptive about when or how this inferred conversation might have taken place.
Yeah.
But your Lordship is quite right that this does arise out of questions of fairness and due process, and I'll show your Lordship the authority on that. And it's...
I mean, there genuinely were no submissions about whether there was a conversation.
It goes further than that, because of course the CMA's case is quite clearly that they do not have to say that there was. So it's not even that nothing was put to that effect, it's that the CMA have said this is not our case, we do not have to go this far. And so the case that the tribunal had purported to adopt is one that not only wasn't canvassed, but was expressly disavowed.
CMA's threshold is much lower. We were taken to Bayer yesterday, which has a slightly different formulation of how you can come to a tacit agreement and acceptance. And this goes considerably beyond that. But if you just sever this, you're not left with a Bayer-type arrangement on the CMA's analysis. This may be completely superfluous and irrelevant, even if you're right.
My Lord, no. For the reason that your Lordship put to Mr. O'Donoghue earlier, which is that this court has to be very careful in relation to findings of fact. Now, the tribunal has made this finding of fact, having had the benefit of hearing the evidence and the witnesses, and it makes clear that this is a finding of fact which it considers to be necessary and to be important. In my submission, it is not open to this court, which is not the fact finder, to select those elements of a finding of fact which it would like to preserve, and to simply jettison those elements of the finding of fact which were not advanced by either side, which were positively disavowed by the CMA, and which were not put to the witnesses. One can't simply save the trial and save the judgment by severing important bits. This is the way in which the tribunal has found resolved the key question before it as to whether there was or wasn't an agreement not to enter the market. It's not in any way peripheral. This is how it has decided that it can uphold this infringement.
But the difficulty I have with this is that true it is the tribunal doesn't really spell out exactly how they've made drawn the inference about the conversation. The fact is that there was the email of the 15th of June in which Mr. Baton accepted he'd spoken to Mr. Patel, and when that was put to him in cross-examination, he effectively concedes, albeit in a rather reluctant way, that was. And the question was put to him, day 3, page 29. So what you told Amit Patel, we see here, is if he did not start supplying you with 10 milligram tablets that month in June, you would launch your own product. Yes? Answer, that is what it, yes.
My lord, yes, and I appreciate that the court is concerned about that particular.
Now, the truth is that I don't think the tribunal will actually refer to that email anywhere.
I have it in my notes whether it does or it doesn't, but I can give your lordship our answer to that point. Mr. Baton accepted the premise that was being put to him, which was that if he received supply from Alden, then he wouldn't need to get supply from elsewhere.
No, it's not.
Sorry, the other way around. If
he accepted that there'd been a conversation in which that is what had been said.
My lord, yes. But the question is,
isn't that the same as the conversation they were referring to at 8?
Is that, no, my lord, it's not. Is that...
Why not?
Because the test is there something more than a unilateral expression? One has to show something crossing the line. What Mr. Baton accepts...
That's crossing the line.
My lord,
unless you start giving us these 10 milligram tablets at £1 a pack, we'll launch our own product.
My lord, yes, and that is a statement, a pure statement of the practicality. It's absolutely right that Mr. Baton is saying, yes, if we don't get supply from you, we'll get supply from Ithaca and we'll go it alone. He is absolutely accepting that those are the two options available. That's the premise on which he's negotiating. Those are his unilateral options. If he gets supply from Alden, he won't go with Ithaca. If you ask, is Mr. Baton there accepting that he is committing to Mr. Patel that he will not enter the market? In my submission, he is not, and it wasn't put to him in those terms. What he agrees with is a premise, and the premise is a practical consequence. If you supply me, I don't need to enter the market with my own product.
Well, what about the question? So what you told, so what, Mr. Baton, you told Amit, we see here, is that if he didn't start supplying you with 10 milligram tablets, brackets at that price, that month, in June, you would launch your own product. Yep.
My lord, I am going to come on. I'm going to come on to address.
That crosses the line, right?
Not in the relevant sense, because what he's saying is, I'm going to enter the market. And what the CMA wanted to say is not
saying unless you give me the £1.
Give me the money, I won't.
No, unless you supply me. Unless you supply me. This is the practical.
At that price.
At that price.
At that price. He's using his leverage to get a good supply deal, and he's accepting when it is put to him the proposition that either he takes the supply from Alden or he enters with his own product, and he absolutely accepts that. The question is that enough to say you, Mr. Baton, committed to Alden that you would not enter with your own product? And my submission will be absolutely not.
And I mean, we're slightly back to the angels again.
Yeah, that sounds like lots of angels dancing on the head of a pin.
Well, my lords, the extent to which it makes sense to dance on the pin depends on how important the issue is. And this is the central issue. Was there an unwritten, on the CMA's case, unspoken understanding?
Well, yes, but this is actually as close as you get to it being conceded. And my Lord Justice Green, who is a notable teacher of advocacy, says that when he taught advocates, he said, if you've got the answer you want, shut up.
My Lord, yes.
And if so you're saying, well, it needed another question so he could deny it.
My Lord, no, it's not to say he can deny it. The question is, are you right that you've got the answer you need? Is there enough here? If I put that if you get supply from Alden, you will not enter the market on your own, if I put that and I get an agreement to that, have I got enough to show a commitment not to enter the market? In my submission, you haven't.
Why not? Why not?
Because All he's agreeing to is the practical, unilateral reality that if you get your supply from Auden, you don't need your supply from Ithaca. What you're not doing is saying to Mr. Patel, I will not come in.
He's saying, if you don't supply me at £1 a box, I will go in the market. And Mr. Patel said, I will supply you at £1 a box.
Right.
So the agreement is, I won't enter the market.
No, you see, that is obviously, that your lordship appreciates, that is where we diverge from your lordship's reasoning. Threatening to enter the market is entirely commonplace. Virtually every generic operator does it. That, in our submission, is not enough to indicate that one is offering a commitment not to enter the market.
Okay.
And that this, I will come on to work through each of the passages.
Well, in fact, he didn't say that. In fact, what he actually said is I told him, if not, in other words, if we don't get this deal at some 12,000 a month, then if not, we will launch our own. So it was a bit more than a threat. I know Mr. Baton tried to categorise it as being threatening behaviour. It seems to me it was a bit more than a threat.
And can I ask you at some point to analyse, and if you're comparing it with the provision, paragraph in the decision, but the buyer test, which is more refined, I think almost on the way you put it, I mean, if you want to just compare and contrast, it's buyer para 102. But you remember that?
Which page is it?
This is Authorities Bundle 90. I just got it out to compare it with what the formulation which you've advanced. Page 3414, tab 90.
My lord, perhaps before we go to 102, we can look at 97, which is in
Yes.
the same judgment.
Yes.
So you're 3414.
341.
So there's no dispute. You're quite right. There's got to be some manifestation or some concurrence of wills.
My lord, yes.
So that's a starting point. The question is, as we're using this vernacular, what crosses the line?
My lord, yes.
And then in 102, you've got the court saying there needs to be an invitation to fulfil a joint goal from one party, and they need the assistance of the other. And then if you go looking at what has to happen from the other person, well, there's got to be some adherence to that joint goal, even if it's not, it's tacit, they say, tacit acceptance. But then you've got the reference in 105 to those old contract cases. What appears to be unilateral conduct in a contractual context can give rise to the tacit acceptance. So comparing this slightly more schematic approach to the email exchange that we've been referring to, haven't you pretty much got that? You've got an offer by one, I need you to keep out of the market. The other one, well, I will keep out of the market if I get a supply at a stonking good price. Okay, and that's what happens then. And it's in a contractual context.
It's a tacit acceptance.
My lord, we absolutely don't take issue with the notion that in theory a contract can come, I shouldn't say contract, a common understanding can come into existence in that way. And so then the question is, well, what have the CMA identified as being that opening offer to achieve an anti-competitive goal jointly? Now, the submission that Mr. Turner made as to what was that essentially invitation to engage in anti-competitive conduct was threatening to come on the market. And the point I make is that if that is all that's required, then everybody is accidentally entering into anti-competitive agreements, because simply saying I'm going to come onto the market, in reality, it cannot. Everybody does it. It cannot be enough to constitute the requisite invitation to achieve an anti-competitive.
Generic
goal.
companies do that, but if the generic company says, I'm threatening to come onto the market, I'm gearing up, so I appear to be realistic, you can't assume I'm not. What will incentivise me not to come off on the market? A supply at an unbelievably imbecilic price. You get it. What more is required? Because it's not just a threat. This is, so you could put it the other way around. The joint project is, I'm going to come on the market unless. The offer, the tacit acceptance could even be by the supplier. I don't want you to come on the market, therefore I will give you supply at a ridiculously low price. paragraph 102 terms, haven't we got a tacit acceptance? I mean, I could see your point on subparagraph 8. They may have put it too high. Mr. Turner's case is much more reflected in the decision, is not that?
My lord, it's not. In our submission, the case in the decision never gets to the point where one actually has the conclusion of a tacit agreement. What one has is unilateral factors, and it never, in fact, establishes that meeting of minds. And I will go through each of the factors and each of the passages that are relied on. There is a subsidiary point. We say that the case that's being put is just not enough. But if the case is being put that you recognise this as an offer to enter into an anti-competitive joint venture, and you accepted it and implemented it, and you thereby conveyed your commitment not to enter the market, that has to be clearly put. And one does look in vain on the documents to see anything that says you're committing to Mr. Patel that you won't enter the market, or you've agreed with him that you won't enter the market. There's nothing that even comes close to that. And it is a matter of fairness.
Apart from the email. Which was...
Well, in my submission, the email doesn't, and it certainly doesn't contain a proposition by this exchange whereby you told him you were going to enter with your own product. You were committing to Mr. Patel, in fact, the contrary, that you would not enter the market if he paid you. That proposition is simply completely absent from any of these exchanges. And when there is, as your lordship rightly says, there's a risk of dancing on pins. But if that's the area that we're in, it's only fair to the witness to make clear exactly what the case is that they're being asked to meet. It's not just as a matter of practicality. If you take supply from Auden, you won't pursue your own independent entry. Not just a matter of practicality,
Can I
but
just
you're agreeing.
put this to you? In the first, when this case started, I thought really it was all about whether there should have been cross-examination to the effect of Mr. Baton, you have just lied to us, haven't you? Which is the good old, if I could put it this way, common law approach to cases. And obviously then I came around to thinking, well, it wasn't quite as unsubtle as that. But I come back to it with this email, because this email is the high spot of what happened, except for the emails to Askia saying cancelling the production, and the email to the staff saying we've had to cancel this production. Sorry, chaps, you've done a lot of work on putting us in the position where we could produce, and now we're cancelling it. So that's supportive of this. What if we look at that page 550, and if Miss Dimitriou had been doing what you say she should have done at this point, bearing in mind that there could be differences of interpretation as to what the email precisely threatens and what it doesn't threaten and all that, what do you say in order to make good her case that there was an understanding as opposed to simply incentives or threatening to enter the market? What should she have said which would have been good enough to set up the case that she ran? What should she have said? Just give me a for instance, as to what question she should then have asked. Having said that, that's what it, yes.
She should have said, and she should have had a basis for putting, because of course the court will appreciate we don't accept there was any basis for putting it, but she should have said, you, Mr. Baton, communicated either expressly or impliedly, or even through a nod or a wink, to Mr. Patel of Auden, that you were committing not to enter the market with your own product. And she can say, I'm drawing this from what you said in this email, what you did here. The nod that we're identifying is you offering, you threatening to come onto the market, for example, because that's the CMA's case. The court will appreciate we do not accept that that is the requisite nod. We say that that's completely commonplace and innocuous. But she should identify.
Could she have said, Mr. Baton, in that email then, you've agreed with me that what you're doing is communicating that you had agreed not to enter the market. That would have been good enough, would it? Or did she have to put it more generally, that there was a general agreement despite, as I think Mr. O'Donoghue would say, despite the terms of the written agreement, you were communicating you wouldn't exercise 2.2 and termination under 17.2. Does it have to go further than that?
My lord, this is not just about the final nail in the coffin, having established that actually there was this meeting of minds. Do you have to then assert that actually there was an agreement? Although we do say that fairness to the witness requires you to put that you committed not to enter the market, which was never put. But there is a prior question as to whether what is going on in this email is sufficient to show that commitment.
So that's a legal question.
Well, it's a factual question in my
It
submission.
wasn't
It's the
only-
factual question as to whether what you, Mr. Bateman, were doing was committing to Mr. Patel that you wouldn't come in. And what he's actually saying is completely the opposite. He's saying, I will enter with my own product. So he's saying...
Provided.
I'm sorry?
I will enter provided.
My lord, yes. He's saying...
That's the rub of this. It isn't, I will do what the hell I like. It's, I will do so, provided the money doesn't keep on flowing.
Well, no, and we will come to look at this email, but the context is a delivery dispute about whether things get delivered in June or July. He's worried that he's only going to get his supply in
Well,
July,
we can't
and he
forget
says,
is
I want it in June, or we'll come in with our own product.
But we have to bear in mind any inference that is going to be drawn from the level of the price. That was part of this, this narrow focus. We won't come in, you will supply, the price will be X. And X is astonishing. Whatever adjective, unusual, very low, preternaturally low, below anything you get in a normal negotiation, etc. That's the contractual context to this. Not contractual, that's the evidential, factual context. Now, how far do you have to go? You know, I'm troubled that, you know, what does counsel have to say? Or do you simply say, I've got enough, I've got context, I've got the answer I need. My submission at the end of the day, at the back of my mind for closings is going to be, doesn't matter to me at the moment whether the cat has twigged as to the relevance of that answer. I bank it, I get the transcript, I add 2 and 2 together with the other things and I make 4. I may win, I might lose. I'm troubled by, you know, if we were to say, to start being prescriptive as to precisely how far someone had to go in a cross-examination, unless it's procedurally unfair.
My lord, yes. We do say it is procedurally unfair, but it's important not to lose sight of... There's a prior question, which is whether, even if it's put and accepted, this case is enough. What Mr. Baton is saying, what he accepts he said to Mr. Patel, is that if you did not start supplying you with 10 milligram tablets that month in June, you would launch your own product. So to which he replied, yes. Now, this is in the context of an email which attached an agreement which permitted him to threaten to enter to launch his own product. Under the terms of that agreement, he was entitled to give 3 months' notice to do that. And so it's very...
This is a week ahead of that agreement.
No, my lord, this is the prior... I can come on to show the document, but the Auden's external solicitors were sending a draft written agreement which contained the right to enter.
It's a week ahead of the signature, yeah.
Your lordship's right, yeah. It contained the right to enter. So he is entitled to say, I will launch my own product, and that is a right that is permitted to him under that agreement. And what we have to assume is that when he says, I told him I'll launch my own product, which he's entitled to do, actually, what he meant was, I am undertaking to you, Mr. Patel, not to launch my own product. And in my submission, that is simply not enough to show a commitment not to enter.
Does it have to be a commitment or an undertaking or a promise? It doesn't have to be that strong, does it?
Commitment is the wording that was used in the decision, and I rather quickly skipped over.
No, I know.
I mean, what as I read this cross-examination, I mean, it really picks up a point my Lord Lodges Green made. It's not in isolation, because this all starts about page 22 of the transcript. But at 26, Miss Dimitri puts to him the fact that having shown him some other emails, and I think what Mr. Clark, at some point what Mr. Clark had said to the CMA in an interview, she says, so the premise for a negotiation like this, Mr. Baton, that's a negotiation with Mr. Amit Patel, is is that if Auden agrees to supply AMCO, then AMCO will not enter the market with its own product. That's the premise of your negotiation. You're doing this instead of selling yourself. So that's very clear. To which she gets the answer, yes, but I'm not saying that to him, which is an extremely canny answer. Because what he's trying to say there is, well, yes, that's the premise. That's what lies behind all this. But I never said anything to him. And then what happens is she takes him to the later email where he does say something, which he has to accept.
My lord, before we move on to the later email, I'd like to grapple with this notion that this premise exchange was very clear. What was put was the premise for the negotiation was that if Auden agrees to supply AMCO, then AMCO will not enter the market with its own product. Now that is absolutely true, and Mr. Baton accepted it, because as a matter of practicality, if he gets his supply from Auden, he won't come in with his own product, and that is what he accepts. The question is accepting that practicality, that's the premise that he accepts, and he says yes, although I'm not telling him, because of course that would disclose my hand to the person I'm trying to get good supply terms from. What he's accepted is the practical reality that if Auden gives him the product, he doesn't need to get it from elsewhere. That in our submission falls way short of saying what you, Mr. Baton, were actually saying was, I am committing to you, Mr. Patel, that I will not come into the market.
But it all begs the question of why. Why should Auden supply for £1 something that's worth £40? Why did it do that? And the only logical explanation, as I think the CAT came to in H2, is if it knows that the underlying position is they won't enter the market.
Well, my lord, Mr. O'Donoghue has addressed you on that point. The CAT did identify an alternative explanation, which was that Auden was unilaterally seeking to offer terms which would incentivise AMCO not to enter with its own product. And now, as long as that is a unilateral strategy, that is not problematic.
Yeah.
But you've got to fit that into paragraph 102 of Bayer. Let's take that as the premise. That was Auden's object. They made that invitation in the terms you just articulated, and that invitation, well, the offer was bitten off. Yep.
My lord,
That's what the email, the email just adds that little bit.
That doesn't amount to a meeting of minds as to you're paying me for my commitment to stay out of the market. The biting off of the hand is saying I'm seeing, and Mr. Baton's evidence was I saw it as a gift horse, I'm seeing very favourable terms, and as it happens, unilaterally, it makes commercial sense for me to take those terms. It's better for me than pursuing my own product. It's not a meeting of minds about I appreciate that Mr. Patel is doing this to keep me off the market, and I'm accepting it, and thereby conveying to him that I understand what he's offered and I'm committing not to come on.
Maybe we've got common ground facts in the way you've described it, and the question is purely and simply how it's then to be analysed in the light of a case like Bayer and the test which it articulates. Does that, or does it not, amount to tacit acceptance for the purpose of Chapter 1 prohibition?
Well, my lord, that was the question that was before the tribunal, and that is the question that the tribunal answered by positing an express exchange between the two parties. That, in my submission, is not the question that's before this court, because it is a factual inquiry.
That's not, because I've just taken your factual premise and I'm applying a legal overlay to it. Gotcha.
Yeah.
In my submission, that is respectfully not right. Because your lordship is extracting one isolated set of facts, drawing a conclusion and saying, I'm going to preserve that because I like it, I'm going to preserve this part, and essentially preserving that part of an overall factual assessment that the CAT made that this court likes, and jettisoning that which it doesn't like. And in my submission, that's not a legitimate approach. We were, I think, looking at what the CAT said.
Yeah, so I drew you down this particular rather long line, Miss Ford, I'm sorry.
My lord, it may be that we can go quicker when I come to deal with the actual cross-examination.
If I shut up.
I will now try and relocate myself in my notes. I think we'd almost finished dealing with what happened in Hydrocortisone 2. We'd seen the CAT reasoning back to the earlier period from its findings in relation to the second written agreement, I was just going to draw the court's attention to page 92, internal page 92, part of paragraph 153. So it's 153, subparagraph 2, and this is the paragraph in which the tribunal makes the finding that Mr. Baton was dishonest. And if we look at subparagraph 2, Roman 3A, on page 92, we see the consequence of our analysis and our conclusion is that Mr. Baton was dishonest at the time of the conclusion of the second written agreement, and he lied about it in the witness box. And then B, it's necessary to be as bold as this, partly because it is the inevitable consequence of necessary findings of fact that we have made. Now, in my submission, what the tribunal is saying here is that the findings it has made about the existence of an express conversation, it doesn't consider them to be peripheral matters. It's saying we consider this to be the absolutely central issue. It was necessary for us to grapple with it. We have done so. But it's saying these are necessary findings of fact. And that does feed into this analysis as well. What happens when we conclude that there was no basis for the tribunal to make that finding? Can the judgment survive without it? And my submission will be, well, clearly it can't.
Just assume for the sake of argument that you're wrong for the reasons that we've been debating for the last 20 minutes.
Yes.
In relation to the email. Now, truth is the tribunal doesn't mention the email, but assume that that's the basis. That was the basis for the 144 sub 8 or whatever it is. So there is a foundation in the evidence for that conclusion. Does 153.2.3a and b necessarily follow from that? Because it doesn't seem to me that it does. It doesn't follow that Mr. Baton. Well, in fact, if I'm right or if we're right in our analysis of Baton's evidence about the email and what the implications were, then he didn't lie at all. In fact, he was reluctantly conceded a point.
My lord, yes, and
I'm not sure what they mean by was dishonest at the time of the conclusion. I mean, do they mean by that he didn't tell the solicitors, or what?
Well, my lord, for my part, I'm not getting back into the questions of dishonesty. Mr. Brealey is...
No, I understand that. I'm just trying to understand the point, really.
The point that I make is that the tribunal is saying it was necessary from its perspective to get into questions of dishonesty because it considers that the points they go to are so central to this case. And that's why it's saying we couldn't just let it go.
Yeah, okay. All right, thanks.
So that was where matters were on Hydro 2. Hydrocortisone 3, what we see in Hydrocortisone 3, as your lordship's been shown already, is that the tribunal is now, in my submission, rightly concerned that no case involving any sort of commitment or promise or agreement not to enter the market was actually put to the witnesses. And what we see, first of all, is the tribunal is again emphasising that it has well in mind the CMA's points that that sort of agreement doesn't have to have a particular form and it can be proven by inference. And say, for example, if we look at 24, paragraph 24, internal page 18, it's talking about its use of the term collateral understanding, but it's saying it might fall far short of a contractual. Such an arrangement or understanding may be neither formal nor a promise nor an agreement, although they can be, but which either on its own or in conjunction with the first and second written agreements constitute an infringement. And then it says at subparagraph 1, as Hydro 2 made clear, an agreement in the context of Chapter 1 is not confined to legally binding contracts, that is any morally binding commitments. Sufficient that the undertakings express their joint intention. What it's doing is quoting the same passages that we saw in Hydro 2. So it has well in mind all the points that the CMA makes about this. It also reiterates the fact, you see, in fact, again, it says at 74, just to pick that up on the way past, under the first qualification, it was suggested that the use of the term promise introduced unnecessary complexity. We don't understand this point. The tribunal accepts that a promise is no necessary part of a Chapter 1 infringement. Judgment makes clear that something far less will suffice to constitute an infringement of competition law. It even mentions the nod and the wink in subparagraph 3. The Hydrocortisone decision says nothing about the nature of the agreement, promise, arrangement, a nod and a wink, save to say that it was one infringing of competition law. And it says at the bottom, in short, the Hydrocortisone decision infers an agreement infringing of competition law, but says nothing more than that. It does not exclude any kind of arrangement, whether a promise or something less formal. So it has well in mind. It's not misdirecting itself as to the test. It has well in mind that it's looking for something that might have any sort of form and that can be proved in by way of inference or indicia as necessary. We then see 82. And in particular, 82 subparagraph 3, where it again emphasises that unilateral conduct doesn't suffice. What needs to be demonstrated is some form of not necessarily contractual common understanding. Common understanding is a term used in this context. It's important to be appreciated that independently arrived at understandings that are common in the sense that they are the same but involve no kind of communication, do not constitute infringements of competition law. So the other thing it's got in its head and it's thinking about is, has the evidence I've heard gone beyond the unilateral and had the requisite quality of crossing the line? And then 84, in internal page 58, what we see is the tribunal's articulation of what it understands the CMA found in the decision. It says the conclusion is this, second sentence, the Hydrocortisone decision found that there was a collateral understanding between Auden and AMCO that crossed the line. I'm just pausing there, footnote 100, it says the Hydrocortisone decision didn't use this terminology. And then, whereby 3, in contradiction to the express evidence of Mr. Sully and Mr. Baton, AMCO promised, again pausing there, 101, you've got again the recognition that something far less would do. AMCO promised not to enter the market with its own 10 milligram hydrocortisone tablet product, even if it could do so, which at the time of the first and second written agreements it could not. It was this finding that the CMA was obliged to defend by putting it to the witnesses called by the appellants. The question now turns as to whether that case was put. And then paragraph 85, the tribunal's concern is, we are satisfied that the CMA never put the case as we have identified it. So there's no lack of clarity about what the tribunal considered the CMA had failed to put. And
Can I ask you just your view on 111, where that does actually refer to the exchange that we've been considering, where the tribunal accepts that the question pretty close to what it was concerned about was put, but all they then say was that all that had to be added was that the denial of the existence of the collateral understanding was not to be believed. And so, as far as the tribunal is concerned, it appears to me they seem to treat the exchange as Mr. Baton denying it, as opposed to reluctantly conceding it. But be that as it may, all they seem to think, in addition, is required is, Mr. Baton, your answer is simply not credible. And he will then say, no, I'm not lying, I've given you the truth, and she could then move on.
Yes, so the tribunal's understanding that he denies the premise. And
Yeah.
But is that right? I mean, they say his denial of the collusion is left unchallenged. I mean, on one analysis of the exchange, reluctantly or otherwise, and whether we knowingly understood it, it could be viewed as a conceding of the critical elements of a tacit acceptance.
well, my lord, the question is, what is the premise that Mr. Baton is accepting? And the tribunal does appear to be proceeding on the basis that the premise that's being put to him is something that he's then denying. But if, in my submission, the premise that is being put to him is simply an innocuous one, that if Auden agrees to supply AMCO, then AMCO will not enter the market, self-evidently, because it's already got supply from Auden. That's what Mr. Baton then accepts. And he says, I'm not saying that to him, because to do so would then give away your leverage. But overall, what the tribunal's saying, it is under the impression that what's being denied is a collateral understanding, and that, of course, is right. Mr. Baton's evidence consistently was that there was no collateral understanding. And that explains why he's prepared to say this. He says, well, yes, but I'm not saying that to him, because what he's accepting is the practical reality that if he gets supply, he won't come in with his own product. There's no surprise that one doesn't say that to Mr. Patel, because the moment he says, well, if you supply me, I won't come in, then the terms of the supply are not going to be as favourable. But
it's striking also that they then go on in 112 to quote the passage from, which is in fact the passage from page, well, that ends at line 24 on page 28. What they don't do is to quote the next bit of the evidence, which is the bit about the email of the 15th of June.
My
Just
lord,
don't deal with that at all.
well, they do deal with it in the sense of
We
discussing.
debated what that means, but if you're wrong about that, and that email does amount to a concession or an acceptance, albeit reluctant, that there was the collateral understanding which the CMA was alleging, then the CAT has simply missed that altogether.
My lord, that's not quite true. There are two references to it. The first is in Hydrocortisone 2, page 475.
But is there one in Hydrocortisone 3?
There is also, well, there is a what I would suggest is an oblique reference, but and I'll pick that up as we go through.
Sorry,
but just to
page
show the one in
475.
Hydrocortisone 2, page 475. What the tribunal's doing here is quoting a large chunk of the findings in the Hydrocortisone decision itself. And if we look at paragraph 6.934 in that quote, subparagraph A is the email that's the first one on Mr. Turner's list. And then subparagraph B is the if not, we'll launch our own, so the 15th June email. So it is quoting that evidence.
Yeah, and it
Right
then
to
goes
suggest
on
that it's
at
unaware that it
134.
exists.
Then goes on at 134, 4 and 5 to say that in effect that the agreement with Waymade for the 20 milligrams was an agreement if they got that deal at the knockdown price they would stay out of the market, and it then goes on to say that was the same deal originally with Waymade and then with Amco for the 10 milligrams. So that's their conclusion based upon those findings in the decision. Which is why I suggested to you that what they actually say in 1448, well, it doesn't expressly refer to that email. May have had that in mind.
Well, Your Lordship has my point about the extent to which they have actually made findings, which is paragraph 92, that what they consider they're making findings on is the individual states of mind. So the unilateral, uncommunicated state of mind of the parties concerned, with a view to what one can infer. But the ultimate question that they're asking themselves quite rightly is that does one then get that communication which crosses the line? And that is what they're deciding by inferring an express agreement.
You said a moment ago there was an oblique reference to it in H3.
In H3, yes. So this is 354. And what I'm referring to is the analysis. There's another of these fairly long paragraphs. It starts at paragraph 81, which is talking about a qualification. But in particular, subparagraphs 4 and 5 on page 354, what they're talking about is the fact that Mr. Baton was bluffing and what significance one draws from the fact that he was bluffing. And the exchange on the 15th of June email was the exchange where there was a discussion of the fact that he was bluffing. So the tribunal is here, while not expressly mentioning the email, it's discussing what one gets out of the fact that Mr. Blayton was bluffing about his ability to enter. And we can see halfway through 4, the fact that Amco hoped, was confident of entering the market is a fact. Mr. Baton described it as a bluff, which could be deployed to threaten ordinary competitive entry. What matters is what AMCO is undertaking in return for the very significant value that was being transferred to it by order, and this was a promise not to enter the market. And again, you see that footnote about it's agnostic, whether it's a promise or something less. It is at this point that it becomes clear what the CMA failed to put. Of course, Mr. Baton wanted a rival supply, and of course, he bluffed to persuade Mr. Patel that such a supply was imminent. But these are, as we have said, background facts. The key question is the one we have framed. Was there a promise not to enter the market? And it goes back to, the decision puts it very clearly, quoting 1.4d, in that agreement, Auden agreed to make substantial monthly payments to Waymade and AMCO in exchange for each of Waymade and AMCO agreeing not to enter the market independently with its own tablets. And your Lordship, have my submission that nowhere in the cross-examination did it come close to saying you were agreeing, or you were committing, or you were undertaking to Mr. Patel that you would not enter the market with your own product in return for what you were being paid. It didn't even sidle up to it. It's simply not put in the terms that it's put very clearly in the decision. My Lords, I think I was still working through what is said in H3, and I'm hoping to at least finish that before we rise. I got to paragraph 85 at 359, which is the one where, having articulated what it understands to be the CMA's case in 84, it says we are satisfied that the CMA never put the case as we have identified it. And my submission is that there's no lack of clarity about what the tribunal considered had been failed to be put. And what actually is going on here is that this is what the tribunal thinks should have been put. This is what it was necessary for the CMA to put in order to make out a finding of infringement, both in law and in fact. This is what it thinks should have been put. Just picking up a final point in passing is relates to the disposition in this judgment, which is at page 147.
Sorry, which page?
Page bundle 393, internal 93. And I just make this point in passing because of the exchanges with the bench about the extent to which we need permission for the points that we're bringing. And our submission is that the points that we make, in particular about the tribunal having exceeded the scope of its merits jurisdiction, and also the point about the existence of a common understanding after Mr. Patel left, are properly respondents' notice points rather than points for which we need permission. The reason I make that submission is because we can see here the disposition of the tribunal. The court has obviously had this exchange about the fact the tribunal doesn't do orders, but what it does do is sit out what it considers to be the way in which it's disposing of the appeals, and it says the appeals in respect to the finding of cartel infringement succeed, and to this extent the Hydrocortisone decision must be set aside. Now the points we make are seeking to uphold this disposition for different or additional reasons. And that's why we couch them as primarily as respondents' notice points rather than appeal points. Now we have sought
But there is a
permission in the
certain
alternative.
elision between the due process point and the merits point. I mean, sometimes in my own head I'm trying to work out which is which, and sometimes they overlap, don't they?
My lord, they do. If the way it fits in is that if the CMA is right that what they describe as a more modest case, and one of Ms. Dimitriou's exchanges with the tribunal, she described the CMA's case as more modest. If they are right that they put a sufficient case, the tribunal has then proceeded to uphold a different case. And one of the key reasons why that is not permissible is precisely because the case that the tribunal has purported to uphold was not put to the witnesses and was not even advanced. And so it follows from the premise of the CMA's appeal that they did not put this case because it was not their case. And they say we don't have to. By definition, it hasn't been put. That material is not before this before the tribunal. And so for that reason, it falls outside the scope of the tribunal's jurisdiction on the merits. And I'll show the court tomorrow the authorities on that.
Hopefully not.
But not tomorrow.
Well, you'll be the only person here.
It's such enthusiasm. My lords, that concludes the points I want to make on the judgments. I can either make a short start on the submissions as to whether the CMA properly put its points or pick up again after.
I think we have done so well today that we can give everybody an extra 2 minutes for their weekend and wish that is a pleasant weekend. We will reconvene on Tuesday, not on Monday, at 10:30.
Court rising.